Good morning. Today we will discuss the forum before which a suit can be filed. Because being plaintiff, you first need to know where and which court should be approached for alleged violation of your civil rights or a threat perception in respect of your civil rights being violated. So it is basically related with the jurisdiction of the courts. Court may have three types of the jurisdiction. One is the territorial jurisdiction, where the court is situated, or where and other part would be the territorial jurisdiction, other part would be the pecuniary jurisdiction, and third would be the subject matter jurisdiction. So first we will take one by one all the three, but before doing that I will tell you the certain golden principles which have been followed while drafting these provisions under CPC, Place of Suing, section 15 to 23, where the suit should be filed. The first golden rule which has been followed is that a suit should be filed where the cause of action arises, irrespective of the nature of the proceeding, nature of the suit, whether it be in respect of immovable property, movable property, wrongs committed to the property, wrongs committed to the person, any type of the suit. The first golden rule which has to be followed is that where the cause of action arose, because it is a cause of action which gives rise a right to approach the court by filing a suit. Second golden rule is that suit may be filed where the defendant resides. You have to keep in your mind very clear this fact that in respect of the immovable property, suit can never be filed where the defendant resides. Suit can be filed only where the property is situated, within whose jurisdiction of the court the property is situated. But if the suit is in respect of the property but for a wrong committed in respect of the immovable property, so suits in respect of the wrongs committed in with regard to the immovable property can be filed, number one, where the cause of action arises, and number two, where the defendant resides. What to do when defendants are many and they reside in different jurisdictions? Then a suit can be filed in a court where any of these defendants resides with the leave of the court. And another second was, what was that? एक्विजेंस तो है ही है. दूसरा जो हम लोग डिसाइड कर बात कर रहे थे, फर्स्ट रूल, सेकंड रूल, suits with regard to movable property. So suit can be filed where the cause of action has arisen, means the where the immovable property was situated at the time of wrong committed to it. And third one, other suits. Other suits can be the suits in respect of not covered under two heads can be filed where the cause of action arises or where the defendant resides. Other suits may be suit for declaration, suit for any wrong committed in respect of the property. So all such suits would lie where the cause of action has arisen or defendant resides. So you see in all types of the suits, the first rule is followed universally, and that rule is the cause of action arises. It is the first place of suing, and residence of the defendant would be material only when a wrong is committed in respect of the immovable property. Only then the suit can be filed in respect of the immovable property where the defendant resides, otherwise not. But if the suit is except this means the suit in respect of immovable property. It can, if it is a suit in respect of movable property or other type of any suit, irrespective of its nature, can be filed where the defendant resides. Now, one more aspect. If this jurisdiction plea is not taken at the court of first instance, the purpose of law is that if the defendant wants to take an objection to the place of suing, he should do it immediately at the first opportunity, and that first opportunity is before the court of the first instance where the suit has been instituted. It should not be the case where the suit has been tried and on a very later stage he says, no, this court has no jurisdiction. So for want of this jurisdiction on territorial issues, the proceeding would not be a nullity. Even the decree has been passed, so it would not be a nullity. But if the jurisdiction is not with regard to the competency of the court, then the decision or the decree may be a nullity. Section 21A has been added in CPC, which says that no suit would lie for setting aside a decree on the ground of place of suing. It means a suit for setting aside a decree may lie except on any ground other than the place of suing. So place of suing, the ground of place of suing has been excluded from challenging a decree on this very particular ground. It very clearly shows that if this plea is not taken by the defendant, then he will not be permitted to take it in an appellate stage or the revisional stage. So a decree would not be a nullity if the objection is not taken at the court of first instance. And I think these 2 or 3 golden rules which I have explained are sufficient to decide the forum where a suit should lie. Thank you.